Miss Norris actively concealed the criminal record of the person that she had moved into, um, not simply failing to mention it, but giving Mr. Norris an incorrect name so that he wouldn't find it.
Norris versus
Um,
Norris, case number 24-127-160M. Both parties are present in the virtual courtroom along with their respective attorneys. We're here on a motion to enter the judgment of divorce and uniform child support order that was filed by the plaintiff, Ms. Wilsner.
Yes, Your Honor. The judgment of divorce was drafted after the mediation was held in this matter back in May. Took quite some time for us to get things in order. But they were in order, and then by the time that they were ready to be signed, this motion by defendant had popped up. So I think there's a little bit of hesitance to enter it, even though it comports with the friend of the court order that was entered in this case and the mediation agreement. So I'm simply asking the court to finally allow these parties to get divorced and to enter that today.
Mr. Browning?
thank you. I sent a couple times the judgment of divorce draft that I received from Miss Wilsner to Mr. Norris, and I think that at this point, the only hesitancy, he's not saying that he didn't agree to these things back at mediation, but we do have the underlying hearing that is of concern to us today.
All right, well, it's a separate issue. Um, Agreement at mediation is an agreement. It's a contract the court has to enforce. So the court will grant the motion to enter the judgment pursuant to the mediation order, and we'll sign that. And now we'll move on to Mr. Norris's motion regarding parenting time. Mr. Browning.
Thank you, Your Honor. In regards to this mediation agreement that was signed, I guess you probably reviewed our brief, but it's been a while. So the heart of it is that Miss Norris actively concealed the criminal record of the person that she had moved into, not simply failing to mention it, but giving Mr. Norris an incorrect name so that he wouldn't find it. Now, he wasn't able to find anybody, I guess, under the name that he was given, so he kept digging. Then he learned that the person that is now living with his kids has a pretty alarming criminal history involving assault with intent to do great bodily harm, for which he served several years in prison, I think 4 plus, and this was against a domestic partner. And apparently he was charged with 2 counts, which we wouldn't know, except that he actually appealed this to the Court of Appeals, that his Hobbs wasn't correct. And basically, according to the guilty plea, he choked his girlfriend, I believe, until, or, something like until she passed out, then came back, hence 2 charges, came back and did it again, I mean. And so this is Mr. Norris's problem with the current custody arrangement is now his kids live with someone like this 8 overnights out of 14, and he didn't get any chance to vet that or even meet the guy or anything of the sort before signing this agreement at mediation. And it isn't so much that this was unknown to Miss Norris. She gave him a false name for a reason. That reason being so that hopefully he wouldn't ever learn about this. And so he's stuck with a custody agreement that he agreed to, which he would never have signed otherwise. And in late September, Ms. Norris continued to express her concern with her living situation and went to Matthew, her ex, well, not fully her ex, but that's a procedural thing we just addressed right now today, about wanting to move out and expressing that this man, Graham, shouldn't be around, shouldn't live in a house with children, and that she saw a side of him that she didn't like. So it's not like that they've lived together and it's been fine, it's been great. Even Danielle is concerned about this living situation. So again, she gave a different name and she gave that same name at mediation when asked to uh, say who her partner was. She's given alternate names of Graham Young, Graham Parker, and his iChat was found under Graham Dickinson Parker, and this was verified using information regarding the license plate. And Danielle isn't disputing that we've now found this person, and well, Mr. Norris did, and his past. And it isn't a one-off that happened years ago. He's continuing to have police contact. He got a disturbing the peace charge recently, and while that is nothing on that level, it it indicates that there is still this concerning behavior, and that is essentially why we have filed this motion for a change in parenting time.
Thank you. Ms. Wilson.
Your Honor, thank you. This motion is actually couched as a motion to change parenting time, but it really is a motion for a change in custody if you look at the request. And I don't believe that they've met the preponderance of the evidence here for Varvarka. There are some inaccuracies in what Attorney Browning has stated. Mr. Norris did meet Graham prior to Danielle and the kids moving in with him. They've met numerous times. They've interacted numerous times. Yes, we aren't in dispute. We aren't disputing the facts of his criminal history, but I think they are, by saying recently he's been in trouble, that was actually before he and Danielle were together. That was, I think, earlier in the year, and they were together. I think they've been together since July. And yes, Danielle and the kids do live with him in his house that he purchased recently. He has his own business. Graham does. I'm not trying to. I don't want to be disingenuous about his criminal history, but the allegations that Danielle has sought some sort of camaraderie with Mr. Norris about how she's not, or she is concerned about the kids in that house is simply untrue. As recently as my last meeting with her, she has no concerns about Mr. Parker, about his interactions with the kids, his interactions with her. There have been no police involvement regarding anything here. There's been no CPS reports, no investigation. And in fact, the kids are happy and healthy, and they're settled in this new home that they've been in since, I believe, August. And in fact, Mr. Norris is relying on Miss Norris to use some of his parenting time for her to keep the kids while he's either at work or while he's in paramedic school. So he's actually giving her more parenting time on the basis of their mediation agreement being a first right of refusal, where she essentially has the kids more than 8 out of 14 days. I would say it's unequal. She has the kids most of the time during the week. And Mr. Norris lives in Spring Lake, which would not be an easy transition for the kids. He could not get them to school on time with his schedules. I'm not sure how this parenting time plan or idea he has will work logistically when he's relying on Miss Norris both for his parenting time and using the babysitter that they have that she has now to help him with his parenting time. Ultimately, though, I think there has not been a showing of a material change that affects the children's well-being at all. And I think this motion should be denied.
All right, thank you. The standard is proper cause or change in circumstance. I guess admissions today convinced the court that there was an omission, at the very least, regarding this person's history, and certainly in the best interest of the children, I think this needs to be investigated. So the court will refer this to the front of the court for an investigation regarding custody, even though it was couched as parenting time. I agree with Ms. Wilsner that this really is, at least the relief requested, is more of a change in custody, and that Mr. Norris is to pay the fee for the front of the court investigation. All right, we're adjourned. Thank you.
Thank you so much, Your Honor.